Good day and welcome to another exciting episode on the Law Lab platform. My name is Aaron Asiedu Enchi. Remember, here we dissect and unpack everything legal. Today, our focus is law of contracts, and specifically, we are moving from the nature and essence to look at one of the foremost elements of a valid contract, that is offer, making an offer. And today, to help us appreciate what an offer is my very good friend who helped us to appreciate the nature and essence of formation of contracts. And he's no other person and he's not new on the platform because we have conferred membership, a permanent membership status on him. That is in the person of Mr. Daniel Odru Minta. We call him the Dateba. I think I explained why he's called Dateba the other time. Thank you. Welcome, Danny.
Okay, thank you very much, Aaron.
I hope you are doing well.
God's grace.
I like your jacket.
I appreciate it.
It's an evidence of good living in this our current economic situation.
I will choose not to respond.
You don't want, well, the platform remains an apolitical platform. Just that you are looking.
I appreciate. Thank you very much.
That's fine. Just so you know, Daniel is married and I am not married. So this is a clear advertisement on my part.
I think we will talk about advertisement and I'll let the people know that it is only an invitation to treat. They need to be mindful of the offer they give. It's important.
Daniel, the other time we looked at the nature and essence of contract, where we appreciated the definition of what law of contract is, even what a contract is, move through the principles, underlying principles of a contract. We understood the two tests the courts use in ascertaining what a contract is, and you briefly actually introduce us to the element of a valid contract. Today, we want to be taking these elements in seriatim, that is one by one. We are looking at offer. We want you to help us understand what an offer is. And you see, the other time you made us understood that an offeror is the one who is making the promises, the promise or promises. And the one at the receiving end is the offeree. Now, my point is, one, what is an offer? And two, in the process of formulating or in the formation of a contract, would every statement the person makes become or is an offer?
Okay, so once again, thank you very much, our students of law and other parties who are listening to educate themselves.
Sure.
I think that again, it is the Law Lab platform. I've already said that this is a good opportunity for students to have an understanding of certain concepts that they've already been taught in school.
Sure.
We are relying on Auntie Christie's book, once again, Law of Contracts in Ghana. We are relying on laws such as the Act 25, the Contracts Act 1960. And also we are relying on studies, knowledge we acquired from our teachers in GIMPA.
I think I added the last time that we can also, people who are watching can also look at the book written by Professor Bonzi Simpson, the founding dean of the UCC Law Faculty, and also later became the rector of GIMPA, that is the whole institution, GIMPA, and now I think he's back at UCC again.
He's a very fantastic lecturer.
Yes.
Okay, so I think that your question is straightforward. What is an offer?
Yes.
But to be able to answer the question, what is an offer, which is the baseline elements that we always establish for us to say that there exists a contract, I think that it is important for us to look at the process of formation of contracts. Yes. Because in forming a contract, we have established that an offeror must make an offer. That has been established. But just like you said, a lot of statements are made, and the court will have to look at those statements and be able to establish which of them was a definite offer.
Okay.
And so it takes time. So in answering your question...
Meaning an offer must be definite.
It must be definite.
Okay.
Not only definite, it must be final.
Okay.
And so a lot of statements are made. And again, I go to the cocoa seller.
Okay.
At that cocoa seller, when I go, a lot of statements are made. Mami, coconut is saying, I mean, me toss say, what is saying. all those statements are made. What the court is seeking to establish is at what point was the offer made?
Okay.
And that is what today's discussion will lead us on to establish in a fact scenario. Which of the statements can we be able to say that whether or not a Lampine statement of A, B, C, D constitutes a definite offer or constitutes a valid offer? That is what we are here to help one be able to answer that issue. Simple. Whether or not the statement made constitutes a valid offer. That is what we are here to do.
Okay.
Great. So, in formation of contracts, a very interesting case of Gibson versus Manchester City Council comes up. And in that case, you realize that Manchester City Council made a statement in a letter form to their tenants.
Okay. So the city council happens to have some apartments they
Absolutely.
let out. Okay.
They let out. And one of the tenants was Gibson. In the letter, City Council stated emphatically that our letter does not constitute an offer.
Okay.
Gibson paid £3, filled the application form, and requested for a reduction in the purchase price.
Okay.
It so happens that after some time, the contract is not able to even materialize, and Gibson goes to court against Manchester City Council. What is the court looking out for? They want to establish at what point was a definite offer made.
Okay, so if I remember the political bit of the case, I think there was change in government.
Yes.
So when Manchester City Council stated that do not consider this as a firm offer or an absolute offer to Gibson. Later, Gibson, who was asking for reduction of price, even accepted and was willing to pay or either paid.
Great.
And so when there was change of government, I think the Labour Party came into government and they actually instructed that they shouldn't sell those houses or their apartments.
Great.
So that is the political.
Exactly. I appreciate the political connotation that you brought to our listeners or our students out there. So the question is, in the formation of contracts, there were exchanges of letters. Gibson filled the application form and sent it to Manchester City Council. The question is that, does the letter constitute an offer? Or is it Gibson's application form that constitutes an offer? Indeed, if you look at the chronology, then it is rather Gibson's application form which will be deemed as an offer which was made. Whether or not that offer was accepted is another question altogether. Because the letter sent by Manchester City Council stated emphatically that it is not definite. It cannot be deemed as an offer.
Do not consider it as a firm offer.
Do not consider it as an offer. So primarily, it means that in the formation of contract, statements are made, conducts are done, words are made. The court's focus is which of these statements, which of these conducts, which of these words can we deem as an offer? The case of NTAC Limited versus Entry is a good case to help us define what an offer is. Primarily for me, I will tell you that premised on that case, I will say that an offer is a definite and final statement or conduct made by the offeror for which a corresponding assent to the terms of that offer becomes binding on the offeror.
That is a solid definition of what an offer is.
Yes.
I would want you to come back to the definition, but what happened in NTAC versus Entry?
NTAC Limited versus Entry is a very interesting case. NTAC Limited makes an offer to Entry, who was a worker in NTAC Limited. Gives Entry a period by which he needs to accept that offer by writing a letter. Entry does that. And the only thing Entry asks, please, I'm bringing this in because very soon we will rely on it. Entry asks that, can I get the bank account details? Later, it so happens that Entry moves away from the from NTAC Limited and later resigns from NTAC Limited, and later they want to say that there exists no contract between the parties. the court's focus, just like I said, is that we need to look at the statements, the conducts that
The
have been made,
correspondence.
the correspondences, and establish at what point was there an offer. The
Right.
court said that, see, the letter that moved from NTAC Limited to Yah Entry, number one, it stated the said property. Number two, it stated the purchase price. Number three, it indicated however the payment is supposed to be done.
Okay.
And so primarily, just like I earlier on defined, the letter was definite, was also what? Final. And so a corresponding assent from a Yah Entry is going to be binding on NTAC Limited versus Entry. So the court stated in that case that your letter was an offer for which Yah Entry has accepted.
So unlike Gibson and Manchester City Council, which Gibson and Manchester City Council, they had the MCC, that is the Manchester City Council, wrote in their letter that do not consider this as a final offer or a binding offer.
Yes.
Here in NTAC versus Yah Entry, NTAC did not write anything of that sort.
No, please.
And Yah Entry accepted it and only asked for their bank details.
Absolutely. And that is because in that letter, certain things were in there, which makes it definite and final. What was there? The subject matter, which is the property which was being given, the number 4 plateau was there.
Wow.
The price was there.
You have an interest in the property.
It is interesting. So primarily, if you want to establish in a fact scenario whether or not the statement is an offer, go back to the case of NTAC Limited versus Entry. Juxtapose it to Gibson versus Manchester City Council and ask yourself that per the letter or the fact scenario, has a statement been made which is definite and final, for which a corresponding assent will make it binding on the offeror? If you see that, then your answer must be in the affirmative. There is a valid offer. It's simple as that.
Right. So, you see, having said this, and clearly looking at NTAC and Yah Entry, and juxtaposing it with what we call
Gibson and Manchester
City Council.
Yeah.
I'm having some kind of, there is that likelihood that, okay, so anytime somebody gives me a letter, let's say I enter into a restaurant and all these places that I'm having menu to choose from, are they not offering me, let's say I have the menu, I have plantain, as an Achem man, it is against culinary practice that you give me yam whilst there is plantain in the kitchen. Mine is plantain and some kontomire, abumu, that. And so you have it on. I ask you that I need plantain and say kontomire stew, and you don't have it, but you are giving me an offer. Is that not the case?
Good.
Can I hold you liable?
Okay, I think that it is a very good point you've made. And so anytime offer is mentioned, another thing that there exists a certain thin line between offer and invitation to treat.
Okay.
And so in NTAC Limited, my same authority, I'm not changing the case. In NTAC Limited versus Entry, if you remember, Yah Entry wrote to NTAC Limited and said that, may I get your bank details?
Okay.
That one cannot be deemed as trying to give a counter offer. We'll get there very soon and then expand on it. It is more of an inquiry. But when you are distinguishing between offer and invitation to treat, you realize that whereas offer is definite and final, invitation to treat is where the party makes a request for people to rather make the offer.
Okay. So comparing offer to invitation to treat, offer is definite and final.
Good.
You get it. And per what you are saying, and invitation to treat rather it's not definite.
It's not definite. It's
you
not
are rather
final.
inviting people
You
to
are
make the offer.
requesting people to rather make the offer.
Okay. Are there types of invitation to
Absolutely.
treat? Okay.
Absolutely. So you realize that I call it the ADACT. Please write it.
It will be on the screen.
It will be on the screen. That is great.
The
ADACT.
Meaning you are going to talk about 5 types of
5 concepts of invitation to treat.
Right.
And so anytime that it is any of these 5, it is not an offer. Take
Okay.
note. If it will be an offer, then certain things must be seen.
Okay.
We've said that an offer is what? Definite and final.
Okay.
Invitation to treat is not definite, it's not final.
Okay.
And so what is it?
Mhm.
And I'm saying that the concept or the types, number one is what we call auction sales.
Okay.
Auction sales are invitation to treat. Number two, display of goods are invitation to treat.
Mhm.
Number three, catalog of goods is an invitation to treat.
Go by your ADAT. So you've
ADAT,
done
sorry.
A, that
Display.
is auction sales.
Yes.
You've done display of goods.
Good.
The
The next A is advertisement.
advertisement.
When you see an advertisement on social media, in the newspaper, please take note. It is an invitation to treat,
Not an offer.
not an offer.
Okay.
C, catalog of goods. You realize that there are sometimes that people have catalogs. You go to their shops
Or
and they
price list.
or price list. It is not it is not an offer. It's an invitation to treat.
Okay.
And the last one is what we call the tender notices.
Okay.
Tender notices. And so you hear people, oh, they've opened tender, I'm putting in a bid for a tender. Please, it is an invitation to treat.
So let's begin on your tenders. You pick them, Sarah, term and
Great.
What is a tender notice and why is
Great.
it not an offer,
Great.
but rather an invitation to treat?
Thank you very much. So now that we have a good understanding of an offer and relying on the case of NTAC Limited versus Aintree and Gibson versus Manchester City Council, we are going to the first topic or type of invitation to treat, which is tender notices. In tender notices, we are saying that tender notices are invitation to treat. Why are they invitation to treat? They are invitation to treat because the company that is opening up for tenders to be made are only giving an invitation to the public. And so you are going to make your tender to the company.
Okay. So
It is your tender, which is an offer.
So say Ghana Post Company Limited puts out a tender in there or announces to the general public that all contractors who intend to work with Ghana Post to build, let's say, a post office in my hometown, Equiase, and put in your bid. Ghana Post is making an invitation to invite contractors to put in an offer so that they will consider which of the offers that is best suitable to them and they would accept. Okay.
Absolutely. That is a more practical example.
But Daniel, say those who work in companies.
Yes, please.
You get to know that, say, let's pick an organization like, let's say, National Insurance Commission.
Okay.
You get to know that they have a particular company that at every point in time, they do supply them, let's say, sanitary goods.
That's true.
So supplying it time by time, would that also necessarily be a tender or there's another definition?
Okay,
for
great.
it?
So let us take some 2 or 3 minutes to explain the concept of tender notices.
Okay.
The case in point is Spencer and Harden.
Okay, Spencer and Harden.
Spencer and Harden. So please take note. The case in point is Spencer and Harden. Again, you look at Auntie Christie's book and you find a brief of that case. You realize that in Spencer and Harden, it was open up for tender.
Okay.
That you can make a tender. The person gave the bid and it was the highest bid and he deemed it as accepting the offer. And the court said that no, it is an invitation to treat. Your bid is rather an offer. And the company has a right to either accept or decline.
Okay.
So if they don't accept, then there is no problem with it. So the case of Spencer and Harden espouses the concept or establishes that tender is an invitation to treat.
Okay.
However, what you are asking borders on what we know as standing offers or requirements contracts.
Okay.
Good. So what is a standing offer? The case of Great Northern Railway versus Witham helps us to understand the concept of a standing offer. So just like you said, there are situations where the invitation statement will let you know that we are not bound to purchase everything from you.
Okay.
Which means that as and when we require, we will come and buy from you.
Okay.
That is a standing offer.
Okay.
If you win such a contract, as and when the company that accepted requires, they will call you, and then that one is deemed as what? A separate contract.
Okay. So I record that in Great Northern Railway versus Witham.
Yes.
They had this arrangement that the Witham should be supplying them with, I think, sand or so for some specific period of time or for some 12 months interval. And one of the times they asked him to actually supply and he declined.
Yeah.
So they brought an action.
When he won the contract, his statement indicated that he was going to supply for 12 months.
Okay.
He offered himself for that.
Oh,
He
okay.
rather made that statement.
Okay.
And so primarily, when you look at the concept, it should have been me. My invitation statement should indicate that as and when I need it, I'll come for it. And so you, the tender, the person who is bidding, be careful of what you are putting it in. That is why we are saying that it is good for students, but also we are explaining the whole concept to the whole, the public at large. That be careful of what you say there, because you might be bound by what you say. And so in Great Northern Railway versus Witham, just like you are saying, you realize that we deem that as any time that we say that we want it and you supply, it is a separate contract.
Okay.
But if I just oppose it quickly to the case of Pebby versus Attorney General,
Okay.
SK Dateban writes an article on
At the
requirements.
JSC as he then was.
Exactly, as he then was.
Yes.
He wrote an article on requirements, contracts, and mutuality.
Okay.
And he juxtaposed Pebby versus Attorney General and Great Northern Railway versus Witham. Please, students, try and read that article. You will realize that in Pebby versus Attorney General, there was mutuality between the parties, that they were going to take everything from the people who won the tender.
Okay.
And so in the statement, they also indicated and prescribed how they were going to terminate the contract. It so happens that the government hospital did not terminate according to what they said. And they said that no, in a requirements contract, you are bound by what you say. You are supposed to purchase everything from what? The people. So although it is a tender, you are still bound by the statements you made as far as the contract is concerned. So Pebby versus Attorney General can be distinguished from Great Northern Railway versus Witham in light of, for us, Pebby versus Attorney General will not be deemed as a standing offer as and when I need it, I can come, because you have already committed to buy everything you need from the people. For Great Northern Railway, as and when you need it, you can go, which means that after a particular or a separate contract is exhausted, I can choose to terminate it or not.
Okay. So that is it for tender notices. So now let's move on to the next one, say display of goods.
Okay.
In shop windows.
Great. So display of goods, there are two cases that you should have on your fingertips. The case of Fisher and Bell and the case of Pharmaceutical Society of Great Britain versus Boots Chemist.
Boot cash chemist.
So these two cases, you must have it on your fingertips. Primarily, all these cases are espousing that anytime you enter into a shop and the shop has displayed their goods with prices, it is an invitation to treat. Take note.
Okay.
So when you go and you pick the item and you take it to the counter, that is when you are making an offer. Okay. And it is up to the person to accept it or not. Let me give you an interesting thing that happened yesterday. I went to the shop. I wanted to buy a bottle of Shito. I picked the bottle of Shito. I went to the counter. I said, I want this Shito. The woman looks at it and says that we don't have the price, so I cannot sell it to you.
Oh.
Yes.
So the woman has denied you your fundamental human right of eating Shito.
Absolutely. But then it falls within all fours in the concept of display of goods.
Okay.
It is an invitation to treat.
Okay.
So the woman said, gentleman, it doesn't matter your money. I am not selling it to you because I don't have the price in the system. It is to establish that anytime there exists a display of goods question, it is an invitation to treat.
I have a friend.
Don't answer it as an offer.
I have a friend who is good at setting up association. He would have set a justice for Shito Eaters association today. Yeah. Okay, so what of boot cash chemist? The boot cash chemist.
Again, that was a self-service shop where the person took a product which was deemed as poisonous per the laws. And then the person took it to the counter and then they indicate clearly that it is an invitation to treat. They can, at that time, there is a pharmacist there who can say that no, this particular product cannot go out. We are not offering it for sale. So you cannot deem that because I have placed it on my shop window, I'm selling it. No, you cannot say that. So please take note. The first one we spoke about tender notices, invitation to treat, display of goods in shop windows, invitation to treat.
Okay. Right. So now we have appreciated tender notices. we've looked at display of goods. Let's look at advertisement.
Another interesting one, advertisement. There are two cases again over there. The cases of Partridge and Crichton.
Okay.
And over there, it is established primarily that where a person makes an advertisement in a newspaper or today's modern world in a social media, it's an invitation to treat.
Okay.
You make the offer. And so when I think the Bramble Cock was advertised and it was per the law, they had to follow a certain procedure, or it was not deemed as one that they should advertise, they should sell. It was deemed as an invitation to treat. So you will make the offer. They can choose to give it to you or not. They can choose to accept it or not.
But would it be in every case that any advertisement placed in the newspaper becomes an invitation to
No.
Okay. In what circumstances would we consider it as an offer that when anyone accepts it, it should be binding or enforceable?
That is a very good point. Before I move to answer your question, I want to add the case of Demenyor versus Johnson Motors. Okay. Please take note, it is a case that also supports advertisement.
Okay.
But is it all advertisements that are deemed as invitation to treat? Just like I stated in tender notices, the statement, if the statement is one which exhibits specificity, it is definite and final, then that one will be deemed as an offer and not an invitation to treat. Let's take the case of Carlisle versus Carbolic Smoke Ball.
I think it's a locus classicus.
It's a locus classicus case. Okay. An advertisement was made, but it was a specific promise for which a performance of an act will make it binding on the people who made the offer.
So help us appreciate what happened in Carlisle versus Carbolic Smoke Ball.
So in Carlisle versus Carbolic Smoke Ball, they made an offer. Carbolic Smoke Ball made an offer that anybody who uses their product will not be able to contract influenza.
Okay. So they made it through an advertisement.
They made it through an advertisement. Okay. And so they gave the opportunity for anybody who will use it, I think within 2 weeks, I stand to be corrected, if you contract the influenza, come for your money.
Okay.
It was specific.
Okay.
And it so happens that Carlisle uses and still contracts influenza. And the court is saying that no, in your situation, it was an offer and not an invitation to treat. Because the operational word I'm using is what? Specificity. It was definite. It was final. Which means that if you perform the act, it is binding. Take note. Go back to the definition of offer as today. So please take note. It's a good point you've raised. Is it all advertisement that constitutes an invitation to treat? No. If the advertisement is one in which the statement is definite and final, then it will not constitute an invitation to treat. The case of Lefkowitz versus Great Minneapolis Surplus Store also is there, where the fair coats, 3 fair coats were advertised for, I think, £10 or whatever price. It was specific. 3 fair coats at this price. If I come, you have to give it to me. Okay. And so, in as much as advertisement falls under invitation to treat, take note. If there is specificity, if it is definite, if it is final, don't go for invitation to treat because you understand the definition of an offer.
Okay. Right. So that is it for advertisement. So we've looked at tender notices, we've looked at display of goods in shop windows, we've looked at advertisements.
Yes,
right?
I think we need to look at catalog of goods.
Okay, catalogs or
price list. And that was that sits well with yours. So I come to the restaurant, you give me a menu, foods are there, you've displayed the price list. I choose one, you say it's not available. Okay. Then why did you display it? But then in the case of Gringer and Son versus Gold, Gringer and Son versus Gold will tell you that where prices are listed in a catalog, it is an invitation to treat. Okay. Primarily, I always say that we need to look at the reasonable man. Is it reasonable so that I can be able to supply if everybody in the world wants that particular product that I've advertised with the price list in my catalog? No, that's impossible. So the courts deem it that no, when you find a catalog with price listing, it is an invitation to treat. When you say you want it and it is available, they will sell it to you. So when you go to the restaurant, they give you the menu and you say, I want this particular thing, and they say it's not available or we won't give it to you, they haven't reached any contract. Okay. You are rather making the offer. They said they won't accept it. Okay. So please take note. Catalog, prima facie, is an invitation to treat.
Okay. Now, so that is it for catalog. Let's look at the last form of invitation to treat, and probably we can bring this section to an end and look
Great.
at other episode by concluding what entails offer. I can see offer is really broad.
It's broad because of the concept of the invitation to treat.
Okay.
The last one is the auction sales. I
Yes.
think that the auction sales is happening all over.
Okay.
And we know that premised on the PNDC law 230, it speaks about the auction sales law.
Okay.
And so this is what borders on auction sales.
Mhm.
And we have numerous cases under the concept of auctions. But primarily take note, auction is an invitation to treat. The case of Harrison and Nickerson establishes that concept.
Okay.
It's an invitation to treat. And we have two general kinds of auction.
That is it. We actually have two.
Great.
Mhm.
Auction with reserved price and auction without reserved price.
What is an auction with a reserve price and
Great.
one without?
So section 4 of the Act 137,
that is the sale of goods.
the Sale of Goods Act, will tell you that if it is an auction with reserved price, that means that the bidder, the agent or the auctioneer can be able to do what? Place a bid. Normally, it is done before the auction starts.
So the owner, rather.
Yes, the owner or his agent
Okay, yes.
can be able to make a bid before the auction even commences.
So let's give a practical example.
Yes.
I'm the auctioneer. Daniel is the owner of, let's say, a car. So before myself, the auctioneer, commences the auctioneering process, what will be done is that Daniel will mention, if it is with a reserve price, would mention, let's say, 50,000.
Great.
If 50,000, so it means that any other bid should be above 50,000. When
Precisely.
it hits below 50, either it is 50,000 or above 50,000.
Yes.
That is the reserve price.
Yes.
If it hits below 50,000, one cannot have any right to action
Absolutely.
to actually enforce that contract.
Yes.
So it should be above the reserve price
Absolutely.
to be able to have that power to maintain an action to
Sure.
enforce the contract.
Sure.
Yes.
You are precisely right.
Thank you.
Under the concept of auction with reserved price, just like you said, it means that if I'm a highest bidder but I'm below the reserve price, I
You
cannot
cannot
get
make
it. Section 4,
Okay.
Act 137.
I think it's in the case of McManus
Versus Fortescue. Correct. McManus versus Fortescue.
Okay.
Again, we are also saying that in the concept of auction,
Mhm.
there are certain things we need to take note.
Okay.
If we are selling in lots, it means that each lot is a separate contract.
So wait, we explained an auction with reserve price.
So let's do without reserve
Yes,
price.
please.
Okay. So without reserve price, and we are looking at the case of Wallow and Harrison.
Yes.
So in Wallow and Harrison, you realize that if it is without reserved price, then the bidder, no matter what the bidder gives, if even it is not as expected, it is deemed as one that the moment the gavel hits, there is a contract.
Okay.
Take note. And so if you go and it is without reserved price, any price that is it. The moment it hits, it means that there is a contract. And if there is a contract, even if I offered something that is not close to what is the appropriate price, you must give it to me.
So another example to just buttress
Yes.
what you just explained. With regards to reserve price, we stated clearly that before the commencing of the auctioneering process, Danny, who is the owner of the car, will mention the reserve price so that it should be above the reserve price before you can maintain an action. But without the auction without reserve price, the owner would not mention any amount. So the highest bidder becomes the winner of the said auctioneering process or the auction.
Precisely.
And so even when the value of the car is 50,000 and the highest bidder is saying, say 10 cedis, you still have to
You have to give because it's without reserved price.
Okay.
Great. So that is a concept of auction. And so with reserve price and without reserve price, McManus and Fortescue, Wallow and Harrison, Harris and Nickerson, these are cases that you must know. Section 4 of Act 137 and also the PNDC Law 230. These are things you need to know. And so if the question borders on auction, these cases must come, these laws must come to enable you answer the question so well. And so we are saying that these are the 5 thematic areas under invitation to treat. But we are not ending there. Before we end, we also have something we call general office.
Okay.
because we are still speaking to offers. When we say a general offer, then it is
Before you move to general offer, so we've gotten the understanding that when we come to, with regards to invitation to treat, we have like 5 concepts,
That's
or 5
true.
kinds of it.
That's true.
We looked at the adult concepts to help for the proper recall or remembrance of these concepts.
Yes.
And we looked at what we call advertisements, auction sales, display of goods. Let me even go by the adult.
By the adult.
So we have auction sales, we have display of goods, we have advertisement, we have catalogs, and we have tender notices. And you took us through by explaining each of them very well. Okay, so you want to add general offers?
I want to quickly add general offers because we say offer. If it is a general offer, it means that it is an offer which is made, or a promise which is made in exchange for the performance of an act through a public notice to either the public at large or to a particular person.
Okay.
Unilateral contracts are mostly general offers. So the question you will ask me is, what is a unilateral contract? If you look at the case of Carlisle versus Carbolic Smokeball, it was a unilateral contract, because a unilateral contract is a contract where a promise is made in exchange for the performance of an act.
So in Carlisle, you made mention that it was through an advertisement to the general public that if you take this, our drug, and you
contract the disease,
and the disease, come for your money. My point is, I took the drug, but I didn't know at the time of taking the drug that Carbolic Smokeball has made such announcement or advertisement through the public. Would I be able to enforce it? I would need you not to answer now. In our next episode, we'll be answering that question and add probably some authorities to it. Ladies and gentlemen, this has been an exciting episode 1 of what entails an offer, or what an offer is. An offer is the foremost element of a valid contract, and it needs to be present. And note that NTAC versus YINT clearly tells us that an offer must be definite, it must be final. Thank you so much for sticking with us through this first phase of appreciating the first element of a valid contract, which is an offer. Thank you for sticking with us once again. Remember, I've always been saying this: do not take all your matters to God, take some to your lawyer. This is the Law Lab. Thank you very much, and see you in the next episode.